I'm happy to be here. My name is Louise Vietepil and I work as an attorney at Rutgers and Pos. Before that I did a PhD degree and I taught here at Utrecht University and I wrote a dissertation on corporate social responsibility clauses in contracts that are used by large multinational companies in the Netherlands, in England and in California. And so I spoke with a lot of companies. I listened to how they dealt with CSR from a legal perspective, but also what kind of compliance issues they ran into. And I think if Ernst mentions the issue of agency, that's mostly a compliance issue as well. So if you have a CSR program and it's not lived up to, who is part of the problem and who is part of the solution. As part of my practice at Rutgers and Pos, I spend about 30–40% of my time advising large listed companies, both in the Netherlands and to a smaller degree abroad, on issues of corporate social responsibility. So this week a large part of my time is spent on advising companies in respect of the non-financial decree and the non-financial directive. Companies have to report on that for the first time this book year, financial year 2017. And so for a lot of large companies, it's the first time that they actually have to do something from a legal perspective in respect of corporate social responsibility. And so companies are still searching how to deal with this. I also advise in respect of sustainability issues and law in general. For instance, one of my clients is a really big polluter in the Rotterdam region, and they want to do things more sustainably, and they're thinking of how, sort of what legal aspects come up, and so I brainstorm with them to see how we can best deal with these things. And so in this lecture, I would like to give you sort of an introduction to corporate social responsibility from a legal perspective. I will talk to you about what kind of issues can come up, how the type of issue that comes up also depends on the company, and to a smaller extent also the company structure. I will speak on the laws that affect what companies do in terms of CSR, and what kind of legal issues companies run into. For instance, if things go wrong and they face litigation. And so I have a couple of examples of Dutch lawsuits in respect of CSR. If you have any questions, or if you want to sort of ask how to see things in respect of the companies that you've researched within the framework of this program, don't feel shy, raise your hand, interrupt me at any given point, as I'm always happy with interaction. So, let's get started. CSR. I will first talk to you about what constitutes CSR, some of the definitions, some of the theory that's behind corporate social responsibility, but then also CSR in practice. What falls within the scope of CSR, the differences for different types of organizations, and then CSR and the law, because after all I'm a lawyer, so that's what I'm specialized in. I will briefly elaborate on some of the legal frameworks and semi-legal frameworks. Semi-legal frameworks are the frameworks that are providing guidance but are not necessarily binding in the sense of the law. And some of the developments over the past sort of 2–3 years in this area, mostly relating to due diligence. And then finally, a bit on the future for CSR and the law. Now the first thing I'm curious about, let me see. What kind of associations do you have with corporate social responsibility? What are some of the matters that pop up in your head? Go ahead.
Thinking about the environment.
Thinking about the environment, yes. Environmental sustainability. Other thoughts?
Good labor conditions.
Good labor conditions, yes, that's a good point.
Fair trade in general.
Sorry?
Fair trade in general.
Yeah, fair trade in general, yes. Other subjects?
Raising share prices.
From a certain perspective, you could also say that, yes. Raising share prices.
Environmental sustainability.
Yes. And what do you, specifically, what do you think about when you say environmental sustainability?
What you said before, a company that is a big polluter that wants to make stuff in a
Yes, and I think the pollution is a different issue than, for instance, making use of green energy or reduction of CO2, but all kinds of environmental issues could fall within the scope. Other issues? Go ahead. Community involvement, yes, that's also, I think it's a bit more of an American or sort of old-fashioned perspective to say if you donate to charities or if you're involved in the community, that could also be part of a CSR program. Yes? Okay. We've already I mean, you've mentioned quite a lot of the issues that are typical for CSR programs. I will first discuss some of the definitions for CSR, and then we can see, depending on the definition, what scholars generally say is falling within the scope of CSR. And so the first definition that I would like to discuss with you is that by Carroll. And he was one of the first to coin a definition for corporate social responsibility, and it's still fairly widely accepted, although it's changing a bit because of new requirements. So he came up with this definition in 1991, so not even that long ago, and he developed a so-called pyramid of corporate social responsibility. And you can see at the base is the biggest, this pyramid of corporate social responsibility, or the pyramid of responsibilities for the company, is consists of 4 layers, and the bottom layer is the broadest and most widely accepted, and consists of the biggest part of the responsibilities for the company. And this is the economic responsibility of the company. So this comprises of providing goods and services, being profitable and competitive, and serving also shareholder interests for the company. On the next level, there's a level of legal responsibilities. And this reflects the sort of social contract that companies are considered to have with businesses. So they incorporate the basic notions of right and wrong, which can be codified and which are frequently codified. But the difficulty is that not everything that is sort of moral or right or wrong is codified. For instance, if you look at the discussion surrounding tax evasion for Apple and other large companies, Starbucks, that sort of try to divert their business so that they only pay a minimum level of taxes. You can see that that sort of raises the discussion of what's legal is not necessarily ethical. And so Carroll has a 3rd layer of the pyramid, which is the ethical layer. These ethical norms go beyond what's codified. So it's not necessarily a matter of do you comply with the law, but it's also non-codified social values and expectations of society. So it sort of also amounts to a gut feeling of do you think that that's something that a company does, even if it's legally right, is it also morally right? So it's a level of social performance higher than what's currently required by the law. And on the top of the pyramid, there's philanthropy, and this also relates to community engagement, which was raised by one of you. It means embracing activities of the business that don't necessarily relate to the business activities itself. Contributing to arts, contributing to education, and local community development. And that's the smallest part of the pyramid. So this is one of the first sort of suggestions from a scholar that said, this is another way of looking at the company. Before this whole discussion was initiated in the 70s and 80s, the whole perspective was companies only had a responsibility towards their shareholders. This is still sometimes raised mostly from an American perspective of the shareholder theory, but in almost all new litigation, both here in Holland, or in legislation, both in Holland and on an EU level, the general notion is companies have a responsibility towards all stakeholders, so not just shareholders. And this is also reflected in communications from the European Union Commission. For instance, in 2011, so already 7 years ago, the Commission stated that CSR is a concept whereby companies integrate social and environmental concerns in their business operations and in their interaction with stakeholders on a voluntary basis. and that corporate social responsibility concerns actions by companies over and above their legal obligations towards society and the environment. And it's more and more on an EU level as well as on national government levels in EU member states, the idea that businesses have duties to wider communities beyond staying within the boundaries of the law and satisfying stakeholders. So the EU Commission basically said CSR is voluntary and it goes beyond what the law requires. It should be an integral part of the business. And it should be noted in this respect that the EU Commission formulated a number of goals in terms of CSR, but that legislation was at the time not necessarily part of those goals. So there was a CSR agenda for action, but no legislation was proposed. And then finally I have one more definition to propose to you, and that's by the Kennedy School of Government. And the Kennedy School of Government is particularly interesting because it's the School of Business from Harvard University. And Harvard University is also the university that put forward Professor John Ruggie, who has played probably the most important role in terms of business and human rights over the past decade, when he became the United Nations Special Representative on Business and Human Rights. And within the course of his work, he proposed the United Nations Guiding Principles on Business and Human Rights, which I'll get back to a bit later on. And they have a very broad definition of CSR. They say the term CSR is often used interchangeably with others, including corporate responsibility, corporate citizenship, but also social enterprise, which is, from my perspective, a different notion altogether. Sustainability, sustainable development, triple bottom line. Does anyone know what triple bottom line means? Triple bottom line is also referred to as the 3 Ps of people, planet, and profit, which some people propose is sort of another way of explaining corporate social responsibility, not just profit but also people and planet. Corporate ethics, and in some cases corporate governance. And though these terms are different, they all point to the same direction. Throughout the industrialized world and in many developing countries, there has been a sharp escalation in the social roles corporations are expected to play. So this again sort of points to the development that whereas maybe 30 years ago or even 20 years ago, people said, bless you, people said the only role that a company must play is towards its shareholders in making profits. That's not acceptable anymore. Not from a legal perspective, not from a moral perspective, and not in terms of what society expects from corporations. It was even the case, I started my research on CSR in 2010. And when I left my previous firm at the Brouw, one of the partners said to me, oh, CSR, that's going to go away in 5 years or so. So that's really just, it's just a fashion sort of research subject, and they all sort of believed it was going, this was a guy who was, I think, 65 at the time, so I think it's also a generation gap. But this is just to indicate that only sort of fairly short time ago, people really had the idea that CSR was just a fad and passing by, whereas with the amount of legislation that we currently have, that's I don't think that's ever going to happen. So, some of the common denominators. What's sort of generally accepted is that CSR is widely considered voluntary, more or less voluntary. I'll get back to that a bit later on. And it goes above what is required by the law, even though you could also ask questions in respect of this criterion. And it concerns obligations that the company has towards society and towards stakeholders. It doesn't just concern philanthropy, although that can be a part of CSR, or of the CSR program. And it concerns engaging with the stakeholders of the company. So saying, what are some of the issues that we encounter with employees? What are some of the issues that we encounter with, for instance, the people in the societies in which we operate? For instance, in case of a polluting company with that operates in sort of the areas where people also live. You have responsibilities towards inhabitants of that area. And it's value-oriented. And the value-oriented issue, I'll get back to in the next slide. If you look at agency from a CSR perspective, my experience is that it really, really depends on the company and the products and services that the company delivers, but also the people that are behind it and the people at the top layer of the board to come up with what they think is the most important in their CSR program. And for instance, if you look at a services-dominated company, a company that, for instance, provides financial services, the issues that are going to come up within the framework of a CSR program are completely 180 degrees different from a company that produces goods and that is a polluter, for instance. And so CSR is such a broad issue that it can really depend on the company what comes up within the scope of a CSR program. So, what does CSR entail in practice? And this is where the issues that you've mentioned also come up. First of all, one of the sort of pillars of CSR is generally seen as economic issues. And this is CSR as well as sort of general compliance, for instance, having a corruption and anti-fraud program. Secondly, the pillar of sustainable development. So, for instance, if you operate in local communities, you need to make sure that that's done in a sustainable manner and done in a way that sort of benefits the community in which you operate. But also social enterprise. So an example could be, for instance, the Tom's Shoes program of a 1-for-1, where if you buy one pair of Tom's shoes, another pair is given to a kid in, I don't know, a developing country. Secondly, environmental issues. So this could be non-polluting, even though non-pollution should really just be a part of legal compliance, even though it's not always. But also, for instance, continuity of natural resources and water. There are a lot of companies, not just sort of Coca-Cola produces soda, but also clothing production companies that use incredible amounts of water, and that's for those companies, it makes sense to consider that one of the main issues of CSR. And also renewable energy, so buying renewable energy rather than non-renewable. And finally, social issues such as occupational health and safety. And then occupational health and safety, not just for the company's own operations, but also in the supply chain. So, for instance, if Coolcat has clothing produced, they don't make that themselves. They buy that from local producers in, for instance, Bangladesh or in China or Myanmar, and they engage with factories to ensure that occupational health and safety norms are complied with within their supply chain. Other important matters are freedom of association and non-discrimination, and I understand that a lot of NGOs see freedom of association as one of the most important things from any perspective of supply chains, because if you are not free to associate and form a labor union, there is no way to effectuate any of the other social or labor norms. So freedom of association and also non-discrimination. There are a ton of issues that I could include that I haven't listed because it's just too much. For instance, the whole livable wage discussion of supply chain employment. But it's by no means exhaustive, this list. And as I've said, the difference is really between what a company does really strongly depends on how big the company is, because not so much to the extent that small companies shouldn't do anything in terms of CSR, but to the extent that large companies generally have a bigger budget to draw up a CSR plan and get people to sort of come up with a long-term strategy. And even if you look at bigger companies, stock exchange listed companies, for instance, one of my clients is in the financial services industry. That's typically not a very CSR sensitive industry, in the sense that if there are violations, they won't really be to the scale of Rana Plaza factories collapse in Bangladesh, but it will be more like privacy requirements are not lived up to. And so even big companies don't always have a CSR program or a CSR director or even anyone to sort of put this on the map. If it's done within companies that don't really have it high on their agenda, it's generally an issue of PR and communication rather than anything else. Whereas if you, for instance, look at companies such as Friesland Campina or other companies in the food industry, they will have a large system of quality controls already in place from years back because they provide food. And so for them it's much easier to sort of create additional CSR requirements within the course of a general compliance program. So it really depends on sort of what kind of industry the company is in, how CSR issues relate to the goods and products that they are providing, or if it's a services company, only that. And what we'll see a bit further on is that because of new legislative requirements, companies are now for the first time, especially stock exchange listed companies, are now for the first time required to report on CSR issues. So for a lot of companies who've never done anything in terms of CSR, they all of a sudden have to come up with a CSR program which they didn't have before. And you can see that they're sort of scrambling to see what's important to us, but also we've never had a budget to do anything with CSR, so how do we go about this? Well, how to go about it is the first thing is finding points to connect with in law and semi-law. And I distinguish between law and semi-law because most of the guidance that is available for companies is not legally binding. So there are now a few acts of legislation on an EU level, but also on a national level, not so much here in Holland, but abroad. But the most widely accepted sources are not legally binding. And there are, of course, some legal procedures, but that's sort of more a way of interpreting the law than it being a source of obligations in and of itself. So the first thing I will discuss are the semi-legal frameworks. And the first and most important from my perspective is the UN Guiding Principles on Business and Human Rights. And as I've mentioned, this was designed by UN Special Representative Professor John Ruggie. And he drafted the Ruggie framework, as it's commonly referred to, and it consists of 3 pillars. The first pillar is the state duty to protect human rights. So Ruggie says if you look at businesses and human rights and the way they interact, there are multiple actors that can play a role. And the first actor that needs to live up to its obligations is the state obligations to protect human rights. So he says the state's duty is to protect against human rights abuses by third parties, and those third parties are generally companies, including business enterprises. And it should do so through regulation, first of all, so coming up with legislation. But it should also do so through policy making, so sort of having a good policy to have businesses think about their human rights responsibilities. And it should also do its job in investigating and enforcing. So simply having, for instance, minimum wage legislation or no child labor legislation is not enough. It should also make sure that these laws are enforced. And this is something that you as economists will generally not sort of run into, but this is one of the biggest issues impeding corporate social responsibility in countries such as India, where they have legislation, for instance, to protect against child labor, but that's simply not enforced. So this pillar reaffirms basically states' existing obligations under international human rights law. So this is really sort of based on existing international law. The second pillar, and that's something that's most directly applicable to companies, is the corporate responsibility to respect human rights. So Ruggie says there are obligations under international law for states, but states are not the only ones that have obligations flowing from international law. Companies also have an obligation, and that is that they should not infringe upon human rights. And he says that businesses, within the course of this second pillar, should act with due diligence to avoid infringing on the rights of others and to address negative impacts with which they are involved. I'm sure that the subject of due diligence has come up over the past weeks of this course. Ernst? Can anyone
acquisition
process. Can anyone think of how due diligence would play a role within the course of human rights and corporate social responsibility? So basically the idea of due diligence is you should investigate what your company is doing in terms of human rights, and you should make sure that you have all the information necessary to make a good decision on how to act. And so you need to basically, as Ruggie says, know and show that you are meeting this responsibility. So you have to, before, for instance, if you have your own company and you think we want to get a product produced in China, you should investigate what kind of corporate social responsibility issues are going to come up if you decide to make such a business decision. And you need to investigate to what extent you can prevent human rights violations from occurring. So it's not possible to just say, my company will go to China, I expect the Chinese government to live up to all of its obligations and to enforce all of the laws that are there. They have to do their own research, and they have to investigate to what extent they have control over human rights violations that can occur within the course of their businesses. So, and that's also this idea of due diligence, which was first proposed by Ruggie in 2011, is becoming one of the standard ways of addressing corporate social responsibility for businesses in legislation. So due diligence was sort of a new bit. CSR due diligence was sort of a new issue in 2011, but it's more and more becoming the new norm for companies, and that takes a considerable time and money for companies to live up to these obligations. So they have to meet the responsibility to know and show, and if they become aware of human rights violations, they need to take measures to prevent and address adverse human rights impact. And this idea of addressing also relates to the third pillar, that victims of human rights abuses by corporations should have access to remedy. Because even if the state lives up to its obligations under international law and companies respect human rights, if something does go wrong, it's important for victims to have access to remedy. So they should be able to initiate a lawsuit or get mediation for human rights violations. And that's something that companies also play a role in terms that, for instance, they will set up their own independent remedy programs in local communities in which they operate. So they should have grievance mechanisms in place in order to effectively uphold the state's duty to protect and the corporate responsibility to respect. And the business and human rights guiding principles have extensive guidelines, also sometimes in respect of specific sectors, for instance the conflict minerals sector, on how companies are supposed to take into account CSR issues when going about their businesses. And even though it's not a legally binding framework, it's relevant in the sense that it's sort of the state of the art of what companies should do. And my feeling is that if companies are litigated against, there are, over the past months, a few new legal procedures initiated, for instance, against oil producer Eni in Italy, I expect that the guiding principles on business and human rights will also play a role in determining what the duty of care will be for companies to go about their businesses. But we don't really know that yet because it's still early days for those lawsuits. So that's the first semi-legal framework. The second are the OECD guidelines for multinational enterprises, which are also non-binding formally. They are recommendations that provide principles and standards for responsible business conduct for multinational enterprises. So the idea is that it doesn't just relate to national enterprises, but multinational corporations. And the guidelines are legally non-binding, but what's interesting is that there are parties that can formally adhere to the OECD guidelines. And so it's both member states as well as corporations, OECD member states, that formally say, we state that we are going to live up the OECD guidelines. And the question then is, what's the status of the fact that they say that they will? Well, one of the matters that, one of the things that is possible under the OECD guidelines that's not an option under the UN guiding principles is that if you're an OECD member state, you have to set up a national contact point. And the national contact point is sort of a secondary way of handling issues outside of the normal legal perspective. So if you have an issue in terms of business and human rights, you can file a complaint with the national contact point against the company, and the national contact point will initiate a procedure that's most like mediation in the terms of that it's not a formal legal procedure. It goes on behind closed doors, so it's not public. And the idea with the NCP is that the NCP comes up with a solution that's acceptable to all parties. So it's not really, in terms of the law, it's not really very helpful because it doesn't really make clear what the expectations for companies are of what they should do and when something is enough and when something isn't, when a company isn't culpable in terms of a CSR issue. But in terms of a grievance mechanism, it's effective because the NCP can investigate complaints about a company. So those are some of the semi-legal frameworks from an international perspective. Additionally, we have, the Code Frijns on corporate governance, which is also non-binding, although there is a it's non-binding in terms of its comply or explain, but the corporate governance code applies to all stock exchange listed companies in the Netherlands, and if they are a large company in the sense of the accounting directive. And this contains principles and best practice provisions that deal with corporate governance in general. But it also prescribes that directors should formulate a CSR policy, and it prescribes that companies have a broader responsibility towards society than just towards their shareholders. So this is again sort of support for the notion that the shareholder theory of only responsibilities towards shareholders is no longer accepted. Companies have responsibilities towards all stakeholders and society at large. So, I will briefly give an introduction. I think it's probably a most logical point to go for a break a bit early because it's a more logical cutoff point for this lecture. After the break, I will dive into a bit more the relationship between corporate social responsibility and the law. So before the break, we discussed what kind of issues can come up within the framework of CSR, how CSR differs from company to company based on what industry the company is in, and what the company formulates as its own values. And in the next bit, we will go into what kind of responsibilities arise within the course of the law. And this is both corporate law, as well as contract law, how CSR can play a role in that sense, and liability law. And I will also talk a bit more specifically about CSR due diligence, as that sort of, I would say a trend, but it's a development that is more and more commonly accepted as the general practice that companies must live up to. And so I propose that we take a break for 15 minutes until, let's say, 5 to 12, and then we'll continue with the legal perspective. I will discuss a number of legal perspectives for CSR. The first is company law, and it's something that you as economics students will likely most easily run into. The second is contract law, and the third is liability law. And at the moment, CSR is most explicitly regulated within the framework of accountancy regulations. So the first is the EU Directive on Non-Financial Information. And this is a directive that was drafted in 2014, which amends the Accounting Directive from 2013. And the Accounting Directive prescribes what large and small and medium-sized companies should do in terms of accounting. But the EU Directive on non-financial and diversity information only applies to large companies and groups. So only those companies that qualify as large within the framework of the Accounting Directive need to comply with these requirements. And it relates to not just large companies, but large public interest entities. And what's a public interest entity depends on from each member state to each member state. In the Netherlands, the requirement for a public interest entity is that it's shortly a bank, an insurer, or a stock exchange listed company. And in order for a company to be large, it must meet certain balance sheet criteria, and additionally, it should have at least 500 employees. And so if you look at the companies that fall within the scope of the non-financial information requirements, it's mostly the biggest companies that are stock exchange listed, because there are no banks and insurance companies that are not listed. But additionally, the Dutch government is now considering whether to also, for instance, require that housing corporations are public interest entities. And if that's the case, they also need to report on non-financial information. And so this EU directive relates to both non-financial information and diversity information. I won't go into the diversity requirements because it's not really my area of expertise, and it also is not really CSR from the normal perspective. And what this directive requires is that each member state drafts legislation that is basically in line with the directive. There are some choices that member states can make themselves, but what the minimum is that companies that fall within the scope of the legislation should report on environmental aspects of their company, social and employee related matters. They should report on their respect for human rights. They should report on anti-corruption and bribery issues. And finally, diversity on the board of directors. So the first 4 criteria of environmental, social, human rights, and anti-corruption issues are typically CSR issues that should be reported on. And the companies that need to report over the course of financial year, with their annual reports over financial year 2017, should explain in the Netherlands, within the framework of their director's report, bestuursverslag, they should report what their business model is, what kind of policies they have in place in terms of these 4 issues, how these policies work in practice, what the risks are that relate to these issues, and they should also include non-financial key performance indicators. And as I've said, there are some choices that member states can make. In the Netherlands, for instance, one of the most discussed issues was the directive prescribes that the accountant that checks the financial reports for that company should mention whether the report is present. But additionally, member states can prescribe that the information that's provided in the non-financial report is also verified. And initially, the Dutch government said, we're not going to do any kind of verification because that's too much of a burden. And then who's going to verify, for instance, if there are human rights concerns within the company? What kind of auditor or provider of assurance services is going to be a suitable professional to do that? But eventually, the Dutch government said, we're going to require that the accountant that also checks the regular financial statement verifies whether it's present and whether there are material differences in terms of financial and non-financial. So for instance, if the accountant has certain information available to him that he's obtained within the course of verifying the financial information and he runs into subjects addressed in the non-financial report, he should weigh these against each other and he should make sure that there are no material differences between the two. And that's something that I advise a number of companies that are going through, that are currently drafting their report over 2017. And the problem is, in the Netherlands, the government chose the accountant to do the limited verification as prescribed by the decree on non-financial information. But accountants themselves don't really know what they have to do. So the way they go about verifying the non-financial part is the same as they do with financial reports. So basically they look at all the numbers and they make sure that there's sufficient documentation to provide assurance in respect of issues addressed. And that's not really what's required by the report. Go ahead.
Who are they reporting to?
This is the annual report that needs to be published under the accounting directive. So depending on the company, that's also supplied to the AFM for listing requirements.
State regulators.
No, the annual report is provided to shareholders, so it's just the annual and director's report. The annual report is more sort of broad financial, and the director's report is the written part on how the company's doing.
Because you mentioned AFM, so.
No, that's really typical for listed companies, and there are a couple of companies that need to provide the information before the publication of the annual report, but the AFM is the eventual authority to check whether it's been reported, but shareholders have separate duties themselves in respect of if annual reports haven't been published or if they're incorrect. But that's a whole different discussion that also ties in with the non-financial information, but it's sort of, it warrants additional research to see what the interaction is going to be if information is published incorrectly, for instance. So companies need to report in respect of these 4 issues, and they are now, most companies are now going through the reporting process and need to get their reports finished. They need to be published in the first quarter of this year, so most companies are currently writing it, and they want to get it completed by the end of February. And so in a few months' time, we'll know what companies are publishing and how they are going about it. But a lot of companies also still need to go into the debate with their accountants, because what I gather from a couple of banks who have, so if you're a public interest entity, there are specific requirements on who can be your accountant. So it's always one of the big 4 accounting firms, but since the accounting firms are sort of going beyond their duties in terms of the directive, they are bringing in much more work than they really need to be, and they're also charging much more for it than they should. So one of the big banks told me that their accountant had said that in order to verify the non-financial report, they would charge 300,000 euros for the work on the non-financial report, which is really sort of disproportional and obscene amount of money for the limited check and limited assurance that they need to provide. So I expect that over the next few months, that's really going to be an additional debate for companies with their accountants in order to see when they comply and who's going to decide whether they comply. Some sort of guidance has been provided by the European Union in the sense that they published guidelines on non-financial reporting. And this is a 14-page document or 20-page document that sets out what the character of the non-financial report should be, and also what kind of issues should be addressed. If this presentation is published, you can find the guidelines underneath the blue link. And basically what they say about the character is that the report should be fair, balanced, and understandable. And that it should be comprehensive but concise. It all sounds very vague. And they sort of give a little bit more indication, but not that much. They say you need to report on the whole breadth of issues, but you should report succinctly, so you shouldn't sort of put in unnecessary information. And a good example of unnecessary information that's put into CSR reports is one of my clients works in the financial services industry, but because they'd never really done a thorough analysis of what to report on in terms of CSR, they just basically come up with all the ideas they could think of that would be good for the company in terms of CSR. So for instance, they say, well, in terms of the environment, there's a bee problem in the sense that there are a lot of bees dying, and so in our office building in France, in Paris, we will put bees on the rooftop of the office building. And that was one of the issues that they included in their non-financial reports. And then the discussion with the accountant was, well, you say that you have 3 million bees on the rooftop, but how can we verify that it's really 3 million bees and not 2.5 million or 2,999,000? So this is sort of an indication of information that shouldn't really be in the non-financial report. It should be issues that are really relevant and that really relate to environmental aspects or social and employee-related aspects, and that are also related to the risks that the company faces. But because by bringing this into the financial report and relating it to the financial reports, this is information that you're conveying to shareholders. So what you're telling about CSR should be relevant for shareholders and should be relevant in terms of financial risk evaluation. It should be strategic and forward-looking, so it shouldn't just be on this is what we've done over the past 2-3 years, but also this is what we hope to accomplish. And these are some of the issues that we can see happening over the next few years. For instance, there's new legislation coming up and we're not sure if we can comply, or there are issues in local member states that we need to address over the next year. And it should be stakeholder oriented. So all stakeholders should be taken into account when drafting a non-financial report. It shouldn't just be, we have so and so many employees and so many are women and we also employ people with a handicap, but it should also relate to the communities in which companies operate, and also address the more difficult themes, so to speak. And the information that's published should be consistent and coherent. And by that it's meant that the non-financial information should be consistent with financial information, and it should be coherent with one another. So all of the issues you should be able to relate all of the themes to one another. And what's important to note is that the EU directive is a comply or explain type of directive. So similar to the corporate governance code, you're expected to report on what you have in place, and if you don't have anything in place, you should report on it. But that sort of provides a way out, even though I don't know any companies that will say we're not doing anything and we'll proudly put it in the annual report. And additionally, there was a lot of criticism for the choices that the Dutch government made. First of all, the fact that the information that's put in the report is verified only to a limited extent, because it only needs to be checked for material errors or material discrepancies between financial and non-financial information. But also the value, and that sort of takes away from the value of the information that is published. But another problem is that those who will be verifying the information are the accountants, and accountants typically have a lot of experience and knowledge of financial reporting, but they have no experience whatsoever with non-financial reporting. And so what most companies are seeing now is that their financial auditors are not even sort of on a speaking basis with the non-financial auditors within the same company. And so they really need to establish a good working relationship to see how do we go about, for instance, reports on CO2 reduction. How are we going to verify whether that information is accurate and correct? Or social and employee norms, because if you have a key performance indicator that relates to social norms, then that also needs to be verified to a limited extent. And finally, and that's a point that ties in with what you mentioned, who uses this information and who checks whether it's there. In my perspective, companies are publishing a lot of the same information in all sources on CSR. So for instance, if they have a CSR webpage, they will explain the same things on the same policies that they will put into their non-financial reports. And it's really not yet very clear what happens if information that's published is incorrect or incomplete, or if information is complete, but the company is so open about risks that would form a lead for additional liability. So the issue really is, what would constitute a good non-financial report? Is it something that's complete in terms of all of the risks that a company is encountering, and does that create additional risks for the company for liability because they are open about things that have gone wrong, and therefore companies can say that they didn't handle with sufficient care? Or is it something that sort of, if a statement is very sort of broad and general and only touches the bare surface, does that even meet the spirit of the non-financial report? So that's something that's going to become clearer over the next year when the reports have been published, and also over the next couple of years to see how shareholders deal with the reports that are published, and also how the general public uses these reports. Because of course, it's not just shareholders that read reports, but it's also NGOs who want to undertake action against a company that they believe is not acting in a CSR respectable manner, so to speak. So this is for the EU and for the Netherlands the clearest reporting requirement from a corporate law perspective. But there's more, and it won't be relevant for each and every company in the Netherlands, but it's really more of a trend. Go ahead.
Could you close the curtain a bit?
Yes, I can. There we are. So the non-financial information directive is the most recent legislation. There's older legislation that was enacted or that was applicable before. The first is the California Transparency in Supply Chains Act, which was enacted in the US in 2010. And it applies to all suppliers that meet a certain financial criteria, I believe $100 million US dollar worldwide turnover. And if those companies do business in the state of California, they have to report on modern slavery and child labor issues. So companies, for instance, such as Philips, who have a worldwide turnover far more than $100 million US dollars, that sell products to Californian customers and individuals, must provide a transparency statement. And they must put up a declaration on their own website that says, this is what we do in order to prevent human trafficking in our supply chain, and what we do in order to prevent slavery in the supply chain. And this was the first act of its kind, and it also provides the clearest indication of what's difficult with these types of legislation. The implementation is that a lot of companies put up a very general statement on their website, so they comply with the letter of the law but not the spirit of the law, because they don't do any actual thorough due diligence. And the information that's provided is a very limited assurance to customers who rely upon that information. So the statements on websites are very vague, and there's very little new information provided, as well as the fact that the action for redress, so if a statement is incorrect or incomplete, there's not a lot of information, not a lot you can do from a legal perspective if you're a customer that relies on that information. And I'll get back to that a bit later on in the litigation part, because recently there has been litigated in respect of transparency statements. And similar to that is the UK Modern Slavery Act, which was enacted in the UK in 2015. And this also has an extraterritorial effect. So it's an act of legislation from England, but it applies to, I need to check what the criterion is, all companies that act, that provide goods or services in the UK and that have a turnover of, I think, 36 million pounds annual turnover. So this doesn't just apply to the big companies in the Netherlands that do business in the UK, such as Shell and Unilever, but it also applies to smaller companies such as Bugaboo and Gols and bike producers that also sell in the UK, for instance. And they also, this bill also requires that you publish a modern slavery statement in which you explain what you do in order to prevent modern slavery in the supply chain. And then there's a couple of proposals and recent acts. First is the Loi Grenelle in France, which I won't go into very deeply because it's really a French act that only applies to French incorporated companies, so with their head office in France. But this is an act that actually goes a step further than just requirements, transparency requirements, because it also requires that that companies have a duty of due diligence. So it's not just explaining what you do, and if you don't do anything, you can also report on that. But the French Act actually says companies must carry out human rights due diligence, not just in respect of modern slavery, but also in respect of other social issues and environmental issues. So if you go about your business, you need to do research as to what human rights issues are that you can encounter within the course of your business. And there are two proposals that are currently haven't been adopted yet. The first is in Switzerland, and this act would only apply to Swiss companies. But secondly, a Dutch legal proposal, the Wetsvoorstel Zorgplicht Kinderarbeid, and that's actually been adopted by by the Parliament, but it hasn't gone through the Senate yet, and I severely doubt that it will actually get there, but I think if it's not accepted, a new proposal will pop up. And this was really by far the most far-reaching of all CSR-related legislation, because it required that all companies, not just Dutch companies, but literally all companies that provide goods or services to Dutch customers, provide a statement that they undertake sufficient care in respect of child labor. So it required that even, for instance, Chinese companies that sell on a Dutch eBay website or bol.com publish a statement that says that they undertake due diligence and due care in their supply chain and throughout their supply chain. So it's not just the biggest companies, it's not just Dutch companies, but literally all companies that have a business with Dutch customers. And go ahead.
But even if that goes through, who's going to look after all the Chinese companies that they?
Yeah, that's one of the biggest issues in the Senate. This was a proposal by the Dutch Labour Party, and especially in the Parliament, most of the parties said, of course, everybody sees that you need to combat child labor, but first of all, who's going to be the authority that addresses whether this law is complied with, and what's going to happen with foreign companies? And the initiator of this law initially said, I think the ACM, the Authority for Consumer and Market, would be the most logical candidate for the upholding of this act. But then the ACM said, no, we're not going to do it, clearly, because who's going to pay us to do it? We don't have the knowledge, and we don't have the budget for it. And so this was put back to the initiator of the law and said, ACM doesn't want to do it. Who else do you think can do it? And she hasn't really drafted a plan. The relevant authority is not explicitly designated in the law, and it's also not explained in the law specifically what needs to be published. So if sort of a simple one-line statement that we exercise sufficient care is enough, or whether you need to actually draft an entire plan. And so that was one of the big shortcomings of the law, that it's very vague, and companies have no clue what would be expected of them. And the idea was that there would be an additional measure, an algemene maatregel van bestuur, to prescribe more specifically what companies need to do and who's going to be the authority in this respect. But that's not been proposed yet, so they don't really know what they're discussing at this point in time. But the idea seemed to be the ACM, and this is an act that has implications for not just civil law but also criminal law. In other countries where they have similar legislation, they choose a combination of criminal law authorities and civil law authorities, such as the ACM. But it hasn't been decided yet. And the problem with the ACM is, of course, that it can't undertake any measures against foreign companies because it only has authority in its own member state. So, where are we? So, all of these acts of legislation have as a general notion that companies should undertake due diligence in respect of human rights. And the question is, just as a sort of background for you, how do you go about CSR due diligence? It's generally accepted that there are 3 steps in relation to CSR. First of all, is you need to get an idea of the types of countries in which a multinational company operates. So the risks in China will be very different than the risks in, let's say, Switzerland or South Africa, because China is notably lax in terms of labor laws and especially freedom of association. Secondly, the company needs to analyze its own business. MNC stands for a multinational corporation, by the way. The company needs to assess its own business practices and policies and the impact that these business practices can have in terms of CSR. And again, this relates to the whole breadth of issues that fall within the scope of CSR. If a company uses a lot of water, then these will play a different role and it will have a different impact than when it is when it makes use of labor in the supply chain and when it produces goods. And finally, the company should draft a plan in order to refrain from contribution to or keeping in place of activities by the multinational company which infringe or pose the risk of infringing on human rights. So that's sort of the steps that a company is to undertake if it wants to assess what kind of CSR risks there are for its own business activities. And these 3 steps and the whole idea of CSR due diligence is something that comes back in each and every one of these acts of legislation which I've discussed with you. So that's really sort of the corporate legal background, and also sort of more the public and open requirements that a company has, in the sense that it needs to report to shareholders and the general public what it does and what the risks are in terms of business activities. But that's not the only interaction with private law that's relevant. And this is something that was probably a bit far from your area of expertise, is economists rather than lawyers. Another area in which CSR will play a role for the company is that of liability law. And that's sort of the question then is, how, if something goes wrong in a company's business operations, how can you go about holding that company accountable from a legal perspective? So the question then is sort of what kind of legal grounds can you use? One of the examples of the most widely published CSR cases are Shell in Nigeria with oil spills and tampering with oil pipelines, which lead to damages in local communities in Nigeria. But also the Probo Koala ship which dumped toxic waste in Ivory Coast. And closer to home, for instance, problems in cocoa producing industries. And the question then is how, if you want to hold a company accountable, who do you go to in terms of which local corporate entity? And how do you go about proving that they did something wrong? And in terms of Shell, the problem with the Shell case is that the tampering with oil pipelines, of course, was done under the supervision, or at least it's assumed, of the local Nigerian Shell entity. And as I've understood you've discussed, the whole idea of corporate structures is if you have a lot of local subsidiaries, and those are the subsidiaries that do something wrong from a CSR perspective, that's the subsidiary that formally you should go to if you want to hold anyone liable. But of course you don't want to go to a local Shell entity, but you'd rather go to the main office here in The Hague or in London, because there's more money, and it's likely that if you want to obtain damages to cover for things that go wrong, it's better to get it from a Dutch or Western entity rather than from a local entity, not even to speak of the problems that if you go to a Nigerian entity, you will have to go through the Nigerian court system, which will likely take very long, and they may be corrupt, and you don't really know what you're getting. So this also ties in with the aspects of private law. You want to eventually, if you hold a company liable for CSR violations, you want to go to the Western entity, and you want to do that through a Western court system. And in order to go to hold the Western entity accountable, you need to be able to find fault from a legal perspective with that Western entity. So in terms of the Shell Nigeria case, what is claimed by Milieudefensie, who initiated the litigation, is they say you didn't undertake sufficient supervision and you didn't take enough precautionary measures to prevent this from happening in the local entity that's under your control. So Shell in the Netherlands, you should have better supervised and better regulated your 100% or 50% daughter company, and as a result you would have been able to prevent these oil spills from happening. And because you haven't prevented it, you should be held liable, and you should cover the damages as a result. And the reason that there's not a lot of litigation in this respect, and also not through Western systems, is because, of course, that's quite a high barrier that you need to find fault with, or that you'd ideally like to find fault with the Western mother company rather than with a daughter that's abroad. And another problematic aspect from the perspective of international private law is, if you hold the Western company liable, you'll generally be able to find a forum with a Western court. But the question is, which law is that court going to apply? Because the general rule is for extra contractual liability. The law that's applied is the law of the place in which the damages occurred. So if damages occur in Nigeria, if you find a forum with the Dutch court is going to apply Nigerian law. So that's, again, another unpredictable factor from a CSR litigation perspective. So this is just a very sort of brief introduction of, if things go wrong, there have been attempts to hold multinational companies liable, but the road to doing so is very long. There are a lot of other procedural issues that can play a role, but it's generally a long road, it's a difficult road, it's expensive, and so it's not very often successfully done. And in the case of the Shell Nigeria case, in respect of 2 instances, the court held Shell liable, but they've now gone into appeals, and so the question is, in the next instance, what will happen then? And then there's contract law, which doesn't really relate to the question of finding fault with companies, but rather in regulating CSR from within the company. So not towards shareholders, but towards, for instance, suppliers or purchasers. So for instance, if a company says, okay, we need to draft a CSR policy, how are you going to ensure that not just your own company, but also your suppliers live up to these policies? And one of the ways in which companies do this is by not just adopting codes of conduct, but by also either requesting that their suppliers sign a code of conduct or adhere to a code of conduct, but also, for instance, by incorporating codes of conduct in contracts. So companies will say, we would like to contract with you to make our iPhones in China, but in order to do so, you don't just need to sign a contract which sets out the financial obligations and production obligations and whatnot, but also sets out how you need to treat your employees, and how many hours those employees are required to work, for instance. And that's particularly interesting because a lot of work for large multinational companies is not done by the company itself within the course of its own business operations, but in the course of a supply chain. And if things go wrong, for instance, in the case of Rana Plaza, where the factory collapsed in Bangladesh and over 1,000 people died, the question is, could Western companies have done more in order to prevent violations from occurring? And then the question of codes of conduct and contracts starts playing a role. Because Western NGOs will say, you had a code of conduct, and for instance, that code of conduct stipulated that you do an audit from a social and employee perspective, that you go to the factory in order to assess whether CSR requirements are met, and you haven't actually done so, and if you had carried out an audit, you would have been able to see that the factory was not safe, and you should have taken away production from that company. So that's another sort of angle of CSR and law, which is increasingly important, but from a practical perspective, it's interesting to note that even the companies that use the most CSR clauses in contracts and documents, for instance, development banks that only provide financing and loans to developing companies under strict CSR criteria, they don't actually engage lawyers in the process. So all of this documentation is drafted by people with a background in sustainability, but they have no sort of idea of whether the contracts will actually end up being binding, because they just draft it from a CSR perspective and not a law perspective. So that's something where there's a bit of room for improvement, that it's not just a code of conduct, but it's also an enforceable code of conduct, and that's something that would benefit a company from being more stable from a legal perspective and less risky from a liability perspective. So finally, a bit of background on legal procedures, some of which I've already mentioned briefly. And so we first looked at what kind of issues can pop up within the course of CSR. We've then spoken about CSR and company law and CSR due diligence, which really sort of provides some indication of what the bottom line is for companies that they should have in place from a CSR perspective. But then, of course, if things go wrong, there's litigation initiated against the company. And this litigation frequently concerns the actual damages that occurred. So, for instance, if there are victims in a local community that suffer from oil spills or bad labor norms, they may initiate litigation. But there are also additional avenues of litigation that can be initiated by NGOs, for instance, in countries here, as well as from consumers. And the first example is Shell Nigeria, in which both the Dutch and the UK Shell entity were sued before the court in The Hague, relating to damages resulting from oil spills in Nigeria. And in that case, the court ruled that the Nigerian subsidiary was responsible for a case of oil pollution, and the district court in The Hague said that Shell Petroleum Development Company, a wholly owned subsidiary, should compensate the farmer, but it didn't explicitly say that the parent company was liable for it. And that's and as I've mentioned, that one of the issues is finding a forum with a Western court so having a Western court rule over your claim rather than a local court. But a second is the Western company going to be held liable, or is the subsidiary going to be held liable? And generally speaking, as a lawyer, you'll try each and every connecting point you can possibly find, so that you at least get a good shot at every possibility. So claims will generally not be initiated just against the Western company, but also against subsidiary companies, because then at least you will get the court to rule on each and every specific case of possible liability. The second case that's interesting from a CSR perspective is a US case of Doe versus Walmart Stores Incorporated. And if you research CSR legislation, there's quite a lot against Walmart, and that's not because Walmart's worse than any of the other companies, but because Walmart as a litigation strategy has the strategy that it never settles. So you will find a lot more claims litigated until the final end. And in this case, Walmart was sued by workers from suppliers' factories in China, in Bangladesh, in Indonesia, and in Swaziland, and in Nicaragua. And one of the legal grounds argued was that the workers basically said, so this is a factory that produces for Walmart. The workers said there was a code of conduct that Walmart had imposed on its suppliers. And so Walmart stipulated that certain labor norms needed to be met. And they said this code of conduct is not just a code of conduct, but it's a contract. And they said, we as workers were supposed to benefit from the clauses in this contract. So we, as a matter of speaking, are third parties to this contract. You also need to comply with this contract towards us and not just towards your subsidiary. And because the fact that there was a right to inspect factories, they also tried to prove that there was not just a right to inspect the local factory, but that Walmart was under an active duty to inspect the factory, and that because it didn't inspect the factory, it was unable to prevent labor violations from occurring in local factories. And then the question is, what did the court do? Well, the code of conduct stipulated that Walmart reserved the right to make periodic and unannounced inspections, and that Walmart will favor suppliers who meet industry practices. And the question before the court was, is this a promise? And if it's a promise that inspections will follow, is it enforceable? And is it enforceable by the local suppliers, or is it enforceable by employees? And the court that came to the conclusion that there was a right to inspect suppliers, but that there was no duty to inspect suppliers. And there was no contractual duty, there was no third-party beneficiary. The employees did not qualify as third-party beneficiaries, and as a result, the employees were not awarded damages and Walmart was not held liable. So that's a good, even though it's an American case, it's a good illustration of how codes of conduct and sort of private agreements between suppliers and multinationals can play a role in local employment conditions and in liability cases. And finally, Tony Chocolonely chocolate, which you all know as a chocolate product at Albert Heijn. A couple of years ago, Tony Chocolonely advertised as being, they still have as one of their main points that they want to avoid slavery conditions in the supply chain. And the cocoa industry is really sort of sensitive from a slavery and human trafficking perspective, and they, as a slogan, use the slogan 100% slave free. And what happened was that one of their competitors, Bellissimo Chocolate, basically said, we also operate in the chocolate industry, and we know for a fact that there is slavery in cocoa supply chains, so you, as a competitor, are unable to advertise that your supply chain is 100% slave free, because there's no way that you can guarantee that that's the case. Simply because of difficulties with cocoa production in Ghana and the way in which the market operates, and that it's very intransparent. And so under advertising regulations, the competitor initiated a claim before the Hague Summary Court, So basically these were summary proceedings in which the judge is unable to sort of make explicit statements on what the law requires, so it only provides sort of a summary judgment on the facts of the case. But the courts, not The Hague but Amsterdam, so the request by Bellissimo was that Tony Chocolonely chocolate would no longer be permitted to advertise as being 100% slave-free. So they said that's unfair commercial practices, you are not able to state that. And what the court did was that they basically investigated the way in which Tony Chocolonely's supply chain was set up. And they said, we need to look at what the basic expectation pattern of the average informed, careful, and observant consumer is, against whom or for whom Tony Chocolonely advertised, and whether those claims are expected to be verifiable or not. And basically the summary court in Amsterdam said, if the cocoa is sufficiently traceable and you can explicitly make clear what your tracing methods are for the cocoa that goes from bean to bar, basically, if it's individualizable down to each bar, and you can prove that the way in which you do that makes sure that there's no slavery in the supply chain, we will accept a claim that is 100% slave-free. And for the purposes of the summary proceedings, the court ruled that Tony Chocolonely had sufficiently proved its 100% slave-free claims. And the fact that Bellissimo brought forward hearsay claims, so basically we hear from competitors so-and-so, was insufficient proof for the court to come to another conclusion. So the court denied all claims to Bellissimo. Nonetheless, Tony Chocolonely individually came to the conclusion that it was probably best not to use the slogan 100% slave-free anymore, because they were sort of made aware of the risk, the legal risk from using such a sort of certain slogan. And so this again highlights the importance of having a good due diligence system in place, also from a compliance perspective, in the sense that if you have a good system in place, you can explain to everyone, to the courts, to stakeholders, to shareholders, what you're doing, and that you're being considerate in not just your claims, but also in the way you go about human rights issues within your company. The difficulty with these cases is that they illustrate that there are most specifically NGOs that will be interested in undertaking litigation against companies in relation to CSR issues. And as we've seen over the past 5 years, there have been increasingly transparency requirements for companies. So companies are required to provide more and more information on CSR issues. But the difficulty is, if they publish CSR information, that information is just out in the open. And the question is, what is going to happen if that information later proves to be false or incomplete, or if it highlights specific risks for the company? And one of the examples kind of relates to the Tony Chocolonely case. Under the Non-Financial Information Directive, companies are required to publish a whole host of information that is related to CSR. But at the same time, the Commission, European Commission, has indicated in its guidelines in respect of corporate social responsibility on unfair commercial practices that all CSR communications that are published by a company qualify as commercial practices. So basically, if a company puts forward a non-financial statement, or if a company puts forward a code of conduct on its website, all of that qualifies as commercial information from the Unfair Commercial Practices Directive. So all kinds of information that relate to CSR will generally qualify as advertising towards consumers. And as a result, if they qualify as commercial practices, companies can be held liable either by competitors or by customers if they feel that they are being misled by this information. So that's sort of a difficulty where the whole way in which CSR and legislation is changing hasn't really been thought through. Because on the one hand, the EU is asking companies to publish more information, but at the same time they're also saying all of the information that's being published is commercial information, and you can be held liable if you mislead consumers or competitors. And the same holds for information that's published as part of the annual report. It's really not clear yet what kind of information is going to be published and what kind of legal consequences that can have from an accounting perspective, from an annual reports perspective, in which the existing legislative framework already offers a lot of grounds for liability, and that now also implicates that CSR reporting can lead to additional liability. So that's something that, in my perspective, really needs to be investigated further, that more information is assumed to be good for the general public, but it's really questionable to what extent that's going to be risky for companies that need to publish the information under existing legislation. So, to conclude, let me see. Oh, there we are. We've looked initially at CSR as sort of a general theme, and we've seen that it's widely considered to be voluntary. But I would say that even though 10 years ago it was assumed that CSR only went above the law, that's increasingly less the case, because, for instance, a non-financial information directive sets out which issues need to be addressed in CSR, and it doesn't say how you need to do it, but it's clear that it's no longer completely voluntary, because you need to report at least on the minimum amount of issues. And CSR is also not voluntary in the sense that it may not be voluntary anymore because of legislation or because of contracts in which CSR instruments are incorporated. So increasingly companies are confronted with CSR legislation, and most specifically transparency legislation. But this transparency legislation seems to be going a step further in the sense that it's not just transparency anymore, but also, for instance, a duty of due diligence or a duty of care. The duty of due diligence is accepted in France. We may get a duty of care in the Netherlands, but I'm not entirely sure about that yet. And there, if that is the case, that really raises additional questions, especially the Dutch duty of care in respect of child labor. So CSR is really an area that I expect by the time you graduate and start working is generally accepted, especially within most larger companies. And I think there's a lot of developments that will go on in the next couple of years, which we don't really know how that's going to go over the next few years. So it's an area on the move. And in my perspective, that also makes it very interesting. And I'll be interested to hear from Ernst next week how you discuss the problem of agency within the subject of CSR. Thank you for your attention.